is the raise hand facility in Microsoft Teams. And can I ask that you don't use the chat facility within this session? Thank you. We have circulated a guidance note number 2, which is available on the examination website. And that sets out the joining instructions and tips on troubleshooting with the technology and the expected conduct for this session. Just to highlight a few key points, as I've mentioned, we will not be using the chat function. Keep the microphone muted. Anyone observing this session should keep their cameras switched off, please, and a microphone muted. This session will only be covering the administrative and procedural matters relating to the next steps for the Central and Eastern Berkshire Joint Minerals and Waste Plan. The main purpose of the session is to review the list of main modifications to the plan that were discussed in the hearing sessions in order that a schedule of main modifications may be prepared for consultation. It is also an opportunity to review progress on the updates to the background evidence that were discussed. It is not an opportunity to reopen discussions on the soundness of the plan. In this session, we will not indicate our conclusions on any aspect of soundness, but we will provide some guidance. In order that we may recommend main modifications, the authorities must formally ask us to do so in accordance with section 70 bracket 7C of the Planning and Compulsory Purchase Act 2004 as amended. When the updated schedule of main modifications has been prepared, we ask that the authorities send this to us for our comments before it is published for consultation. The minimum period for consultation is 6 weeks. Could the authorities make clear in the consultation that representations should be addressed solely to the proposed changes and their implications? It should also be made clear that the main modifications are put forward without prejudice to the inspector's final conclusions. The consultation exercise should also draw attention to any evidence documents that have been updated. If the authorities intend to publish additional modifications for consultation alongside the main modifications, it should be made clear that the additional modifications are not matters for the inspectors. In the current schedule, there are some additional modifications that should be main modifications. We have discussed these and we'll go over them again today. For clarity and to avoid an excessive number of main modifications, it is best to group all the changes to a single policy together as one main modification. This will help the registration process for each of the representations. The authorities will need to carefully consider the need for addendums to the sustainability appraisal and the habitats regulations assessment as a consequence of the main modifications. Okay, firstly, can I ask the participants for this session to introduce themselves, please?
Melissa Spriggs, Planning Policy Manager at Hampshire Services.
Thank you. Okay.
Michelle Kidd from the Environment Agency.
Okay, thank you.
Joe Marchant from the Environment Agency.
Okay.
Elena Todorowska from Hampshire County Council.
Thank you.
Sophie Champion from Hampshire Services.
Okay, thank you. An outline agenda for this session has been circulated to the participants and any observers by the programme officer. Are there any procedural questions before we start?
Not for me, thank you.
Okay. Right. Okay. Now, the first item on the agenda is the position on the signatures for the outstanding duty to cooperate statements and other statements of common ground. Now, I think at the first session in matter 1, we noted the position on some of the duty to cooperate statements. Could you just outline where we have got to on those, please?
Yes, certainly, thank you. I'm very pleased to inform you that we've now had Slough Borough Council have signed off the statement of common ground, so very pleased with that. We've also had signatures on the soft sand statement of common ground and the sharp sand statement of common ground from Wiltshire Council. Unfortunately, we've not been able to obtain a signature yet from Buckinghamshire Council, but as you're aware, they have been engaged in the process and have indicated that there shouldn't be a problem. It is an administrative issue, but they will be signing. And I can also report that we are now engaged with Central Bedfordshire, and that discussion is to be ongoing at this point in time. They've provided comments on the statement of common ground, highlighting that obviously there's now information on the national collation data that was published from MHCRG in August. So there's further discussions to be had with them on the statement, but they are now engaged in the process.
Right, thank you. And does that give you the full set of statements of common ground?
They were the outstanding signatures we were waiting on, yes.
Okay. So you've indicated that Buckinghamshire and Central Bedfordshire have yet to sign. Is it possible to give any indication of the likely timescale for that, please?
For Buckinghamshire, we're hoping to be able to speak to them this week. It has been a matter of trying to get hold of them, but as I say, as I spoke to them a few weeks ago, there was no indication that they wouldn't sign. It was the person involved, who I believe is one individual dealing with minerals and waste matters at the council, trying to get the right person to sign it off, but they suggested there was no problems with that. I will continue to chase them. We have chased since the hearing sessions last to try and encourage that on. And as soon as we have that, we will let you know. And as I say, with Central Bedfordshire, no indication yet. With this is the first set of comments we've had on the statement of common ground. They recognised that they had correspondence from us before and apologised for not sending comments through. And I think there's further discussion to be had on the statement. They've obviously highlighted the national collation data, which does actually highlight that there is a relationship between Berkshire and Central Bedfordshire. So we just need to sort of progress that conversation with them. So I can't give you an idea of timescales just yet, but they are fully engaged, which is a good step forward.
Okay, well, thank you for that. When these are progressed and completed, could they be uploaded onto the examination website, please?
Yes, we will do that. Thank you.
Right. Are there any other points on the statements of common ground, duty to cooperate? Okay. Right. The next item 2 on the agenda, is the strategic flood risk assessment. Now there was the last one was dated in September 2021, and I think since then we've had a revised one dated October. Firstly, can I just ask the authorities, please, could you just outline the differences between the October one and the September one, please?
Certainly, thank you. Following the last meeting, you'll remember that the table in the background, the back of the document outlining the explanation of the sites has been updated. I think it's table 2. That now incorporates the flood risk zones that are relevant to each of the sites. It also has a more simplified explanation in the update column on the far right hand side to make it clear about when the sites have been considered and why they may have been ruled out from further consideration, which helps explain the sequential test and why those featured and some didn't. We've also got information in there about the climate change allowance section. We met with the Environment Agency last week to discuss this point. They understood the process we'd undertaken. They did express in the meeting that there was potentially some further concerns, and you will note that we received a letter from them at 5:30 yesterday evening. So I would like to just point out that I've got colleagues looking into that at this moment, and if it was possible, it would be helpful to have a little bit more time to come back on the climate change allowance points and the reference to the Thames modelling that was mentioned that hasn't come up previously. So I've got a colleague who has contacted someone at the Environment Agency is hoping to get hold of some information to see whether that has any implications for the sites in the plan.
Okay. Yes, so could you just sort of leading on from that a bit? I mean, you have explained that, but can you just sort of so what are the outstanding issues? Could you just outline those, please?
We have based our approach within the SFRA on an approach that was taken on another local plan within the Thames region, the Hart District Council plan. And my colleagues have looked at the climate change allowances, which are the same. You have to excuse me, I'm not quite as technical as my colleagues would have been on this. It's the same catchment and would apply the same climate change allowances. So that's the approach we've taken to in the plan. And obviously there's been comments previously about the requirement to the Environment Agency tried to encourage us to do modelling, but we don't think, based on the sites that we have got and applying the climate change allowance, that's required at this point in time. However, in the letter outlined provided yesterday, it suggested that there's some Thames modelling that the Environment Agency have got, which hasn't been available. We weren't aware of this previously, and hasn't been mentioned in previous discussions or in the correspondence that I've looked rapidly this morning that we've had from the Environment Agency. So, as mentioned, that's not something that we've applied. My colleague is speaking to the Environment Agency this morning to try and get that information to see if it makes any difference to the sites of which there's some concerns would be impacted by climate change, applying climate change allowances.
Yeah, okay, so from just briefly reviewing the Environment Agency's letter, yeah, okay, well, so the next steps then, you intend to meet further with the Environment Agency to resolve this matter. Can you give a likely timescale for that, please?
We are hoping, if it was possible, to give some time this morning and maybe possibly have an answer on this afternoon if my colleague can get the information that she needs. It could be that we could get back to this afternoon if the session allowed. if there's only a couple of sites that this would need to be checked against. So she's trying to get hold of that information this morning, and if needs be, she can also provide more information because my colleague was the one that worked on the Hart District Council SFRA, so has got much more in-depth knowledge of that. So if it would be possible to pick this up this afternoon, she may well be available to provide some further update on the findings and also the approach she took for the Hart District Council SFRA. If not possible, we could, pick up this discussion further with the Environment Agency outside of this session, if possible.
Okay, well, I mean, yes, we could potentially come back to this later on today in an afternoon session to allow time for this to be properly looked at between yourself and the Environment Agency.
That'll be helpful, thank you.
Okay, shall we park that there then for the moment and come back to it and move on to the next item on the agenda, and that's yes, item.
Hello, excuse me. I did raise my hand. It's Michelle Kidd from the Environment Agency here. So just following that, to be clear, what's the expectation for today in terms of reviewing the SFRA? And because I'm not sure what the accounts are intending to do with that data, because I don't think we'd be able to review it and come back within one day, within the day for this afternoon. I don't know what the expectation is on resolving it, reviewing it. Is this an amendment to the SFRA? Yeah, I just wondered what that means for the next steps.
Okay, Miss Spriggs.
We were hoping to be able to determine by close of today whether any additional information was likely to change the outcome of the content of the SFRA. If there's further data that can have an impact, then obviously we could make further updates to the SFRA and it could be the final version. But I was hoping to be able to conclude today for your purposes whether the additional modelling that we've now been made aware of in the Thames modelling, whether that information changed any of the outcomes of the SFRA, so you have that information available today. If that's not necessary for you to have that information by close of play today, then we can obviously follow that up and have further discussions with the Environment Agency to sort of finalise the SFRA. But as far as I'm concerned, and I understand from the letter, that's the last outstanding matter. And as I say, it only relates to, I think, 1 or 2 sites within the SFRA.
Okay, well, any further information would be of use to us if it can be provided today. But on the other hand, we reserve our position that we may have to come back to this, and so we're not necessarily going to reach a conclusion today. I acknowledge that, but if there is further information that can be provided, that may help us. But I think it might be advisable to, if you're available, Miss Kidd, this afternoon. I think Miss Spriggs indicated that we could have a further discussion on this afternoon. I don't really want to sort of reopen a full hearing session to discuss the merits of it. Really, we're just going, through what the outstanding issues are, to be clear on those and what further actions will be taken. I think that's what we need to know at the moment, and the timescale for completing those actions. So if are you available this afternoon, Miss Kidd?
Yes, and I'll have to check that my colleague Jo Marchant's available also. because that will be really important. But I just that data has always been there, the Thames data available for our model data that we have for informing any flood risk or SFRA, and then I just wonder how that's going to be used and then interpreted, in how that's going to be used in informing this SFRA and the sites and the requirements that we have for climate change allowances.
Yes.
So that would all have to be understood and reviewed. So perhaps we could discuss it a little bit more this afternoon, but I don't think we would have been able to review that in one day and turn that around.
Okay, well, I know what you say, and that it might not be possible to resolve this matter in such a quick timescale, and that further time may be required. But shall we just revisit this afternoon when we've all had a chance to look at the documentation further and to review the situation?
Okay. Yes.
Just to determine what the next steps are, really.
And what time will that be? What's the afternoon session? Shall we come back to this?
Well, shall we say 2 o'clock this afternoon?
Okay.
Okay. Is there anything else at the moment on the SFRA? No. Okay. Okay. Well, shall we go on then to the next item on the agenda, which is the. I have a note. Yes, the prior extraction threshold. That's a 3 hectare threshold for prior extraction. And this was discussed on matter 5. We discussed the prior extraction threshold, and we said that there needed to be some evidence to underpin the choice of the 3 hectare threshold. And you've forwarded a document to us entitled Safeguarding Threshold, dated October 2021. Could the authorities just please give a bit of extra explanation to support that document, please?
Thank you. I'll ask my colleague Sophie Champion to talk you through that if that's possible. Thank you.
Good morning. Yes, following on from these sessions, we did an exercise to try and provide some evidence as to how many applications would be affected by that 3 hectare threshold. Rather than just going in on the 3 hectare, we decided to apply a bit of a above and below type situation to show how the sites would be affected. We used a bit of a coordinated approach because there were 4 different searches going on between the different authorities. So the criteria of the search are set out in paragraph 1.2, so 5 years worth of data, only new developments, so not anything like refusals or withdrawals to avoid too much duplication, and any part of those application sites falling within the safeguarding area, whether it's all of it or just a tiny fraction of it. And they were grouped into those bands that you can see in the table. So the evidence for our 3 hectare threshold hopefully shows that below that you start rapidly increasing the level, and we were concerned that it might place an undue burden on both planning authorities and all of the developments themselves, having to conduct a mineral resource assessment when our conversations with industry, and have been confirmed by industry, suggest that from 3 hectares a site is viable for extraction, prior extraction, I should say, not incidental extraction. So that's sort of summary of our approach, and hopefully shows the evidence as to why 3 hectares seems appropriate and captures the most amount appropriately.
Okay, thanks. In paragraph 1.2, you say only new development applications. Does that just mean new operational development?
Yes, any sort of residential or office or new development, not things like housing extensions, I think. Trying to simplify it and the number, volumes involved.
Okay.
Right, so just to clarify then, so when you say you've excluded householder type development, so that would still be operational development, wouldn't it, in the legal terms? We're just trying to understand, is it a size threshold in total that you've used, or have you looked at the types of development applications in there? So can I assume you've removed material change of use? So anything that's just a pure change of use, you wouldn't have included that in the search?
No, that wasn't included, no.
Right, thank you.
And in paragraph 1.4, you say in the last part of that, you say the justification for the threshold is to avoid requesting mineral resource assessments where viable prior extraction would be unlikely. And isn't the purpose of the mineral resource assessment to determine whether prior extraction is viable or not? So shouldn't I mean, if there is any doubt, isn't it the case that a mineral resource assessment would determine the position?
Sorry, I'll let you answer. Yes, the mineral resource assessment is what's used to make the judgment. The 3 hectare is to pick up those that are potentially going to be viable at a 3 hectare threshold. But what you might find within that 3 hectare that there may be site constraints within that would mean that there wouldn't be sufficient material that could be extracted suitably from that site. So we use the area initially to do the first sort of sieve of those that are potentially suitable. Then we require a mineral resource assessment to then provide the detail about the quality and the quantity of material and the specific site characteristics that could impact whether prior extraction and to what depth potentially is suitable within those sites.
Okay. Thank you. Is there anything further on that matter, the prior extraction threshold? Okay, the next item on the agenda then is the actual schedule of proposed modifications. We received a document last week, a schedule dated the 12th of October, and then we received another one yesterday. Could the authorities just, is there a difference between the two? I think it is, or is it the same document?
Apologies, we wanted to try and give you as much foresight as possible on our changes to the proposed modifications, which is why a version went up to you on Friday. There has further work, particularly on policy DM15, and we also received, following that submission to yourself, comments from the Environment Agency on the Monkey Island wharf development considerations. And I don't believe that the version that was sent to you on Friday had got an update to the numbering. It was showing where there was new main modifications, but I don't think the numbering had been applied. So the version sent to you yesterday is the most up to date, so includes our hopefully final proposed modifications for DM15, the Monkey Island considerations, and all the numbering has been updated. We've tried to reference where possible if this is a new modification or whether it incorporates or was a former modification in the previous version.
Okay. Right. Okay, thanks. Now, can we haven't had a chance to go through this in, well, you know, we will need time to go through it in full detail, but if we could just go through the main modifications and the additional modifications as they appear in the schedule. So if we go through sort of on page number, starting on page 2, and we've got a new main modification there for references to the NPPF. Yeah, similarly, page 3, we've got MM2 makes reference to the NPPF. MM3 that includes a clause to address the causes of climate change. MM4. Oh, wait a minute. Oh, right, this is where the numbering of the modifications has changed, isn't it? Which is where it gets a bit confusing, because we've got in the latest schedule the MM numbering is different from in the previous schedule, isn't it? Shall I just sort of highlight the ones where I've identified particular questions remaining? Is that the easiest way to go through this?
That's probably. There's a number of main modifications, partly because obviously we flagged up last time around that there's been an update to the NPPF since submission.
Yeah.
That's resulted in a large number of changes, which, as you flagged up, was main modifications. We've tried to put everything in plan order, and as I say, so any new modifications have got in brackets afterwards new. As I say, any that were previously discussed as main modifications or were additional modifications that you requested that they were main modifications, we've put that reference underneath. So I hope that does help follow our order. Okay.
If I could just sort of highlight particular ones where I've got questions. On policy DM6, And in the latest schedule, that's MM17 on page 10.
That's correct, yes.
Paragraph 3 of the policy as amended, it says waste management facilities, including aggregate recycling facilities, will be permitted where the proposal is not inappropriate development or where it can be demonstrated that. And then you go on to list criteria. I think instead of or, it should say and, because you need to consider firstly whether it's is or is not inappropriate development as a first stage before going on to consider other considerations. You know, so firstly, in applying national greenbelt policy, the first step is to consider whether it's inappropriate development, and then if it is inappropriate development, then you go on to consider whether there are very special circumstances.
That was how it had been. That was how we had planned for it to be interpreted. If it's, but I can see how being read in a slightly different way. It was meant to be the first consideration, yes, whether it was inappropriate or not. If it's not, or if it is inappropriate, the second part comes into play. So yes, I can see on that. So no, very happy to make that change.
Okay, on policy DM7, which is MM20 in the latest schedule. And there you've taken text, it was in the background text, and you've inserted that into the policy in paragraph 1, as I think that's word, it may be word for word the same text.
That's correct. It was in the additional modification we were putting in the supporting text, but under discussion at the last session and in conversation with my colleague, we felt that that was best placed up in the main body of the policy. So it has the introductory section about the hierarchy of assets, and then makes the point later on about recording and makes specific reference, obviously, to the historic environment record as well.
Okay. Is that particular text, is it necessary? Is it justified? Or does it make the policy effective?
We believe so. It's meant to, in part, balance out the fact it's not just focusing on archaeological information, but also in response to some of the comments we'd had from the Berkshire Gardens Trust in terms of recognising the importance of recording the information and making sure that things were recorded not just in the public archive, but also where necessarily in the historic record, historic environment record. So we felt there were additional beneficial text based on the comments we've received and also from the discussion we'd had at the last session.
Okay.
Just a question from me. In that new text under criterion 1, you've used the word undesignated heritage assets. Is there a difference between undesignated and non-designated?
In terms of the protection, we have tried to pick up where things are designated or undesignated, and then those that were I have to find the wording there, apologies. We'd picked up before about those that were recognised as being recognised or not. So we've picked up the fact that things are locally recognised recognised assets, but then also trying to pick up the undesignated ones as well. So it's meant to be a sort of hierarchical list for applying those points.
Yes, the reason for my question is when you look at the criterion 5, you've got you use non-designated there, and I'm thinking someone reading the policy might think, right, designated, then non-designated and undesignated, and are there 3 terms when actually there are only 2, aren't there?
Oh, I can see for consistency purposes that doesn't flow quite as well, so we'd be happy to make sure that was a consistency point in terms of part 1 and part 5.
Okay, thank you. Because the other thing that we talked about in the session was making sure that the public benefits test was clear, that it was only relating to the designated heritage assets, and I'm not seeing that really coming through in main modification 20. So I wonder if you could just have another little look at that for us, please.
Okay. Yeah, that's fine. Thank you very much. Sorry.
Okay, now on to policy DM15, and that's main modification 30. We had a discussion about this in the hearing session, and you've altered the wording to refer to site history. Do you wish to say anything further about that modification?
I'll pass to my colleague, Alina Todorowska, if that's possible.
Okay.
Hello. Yes, so after our discussion and based on the MPA's comments that we should be looking at land use, we've tried to change it so that it focuses on land use. So whatever has happened at a certain site, that's what we're trying to use as past information to give us future predictive information of what land uses this site could support. So we focused on a history of minerals and waste activities. We're still looking at any issues that may have been arisen, but we're focusing on whether a particular land use can be made acceptable on a particular site. We also did some thinking about kind of comments that were raised. So we've highlighted that particularly relevant will be those activities impacts, potential impacts or mitigation measures that are similar to the ones proposed. So we're trying to help make that linkage of kind of how you look at the past history. So if there's lessons to be learned specifically. Because we were talking about who will provide what information, we've added a bit about how the applicant will need to kind of provide some of the information, but that the rest will be collected from other sources like the monitoring officer, site operator, liaison panel, etc. So we've just added a bit of information where that information is coming from. We've renamed the monitoring assessment to monitoring information to clarify that the assessment is done when the application officer, planning officer makes his decision and does his their officer's report, whereas this is just about the collecting of information. and basically how that information is the evidence that then can be used to make judgments based on this policy. So hopefully we've set out that in the policy, and then through the supporting text, we've highlighted how the monitoring information will be collected. And then at the end, there's the bit about how it will then be used to request more information and more mitigation measures, etc. And in line with all of that, we've amended the monitoring indicator as well.
Okay. Yes, and that covers main modifications 29 up to 36, doesn't it?
Yes.
Okay, well, thank you for that. Anything further on DM15?
No.
Okay. Yes, actually, can I go to policy M2? Yes, policy M2 doesn't actually require a minerals resource assessment to be carried out explicitly in the policy. I think that's in the background text. Should that requirement for a minerals resource assessment, should it be explicitly stated in policy M2?
There's a tool in which we would get people to demonstrate that, but we would be very happy to make it clear that that is what is expected. So I'm very happy to add that in as a requirement.
Okay. Right, thank you. Right, and the term appropriate locations is referred to in a number of the policies, and you have made some modifications to clarify, to define what that means. I'm not sure if there is one relating to policy M4. I think I couldn't see one anyway. It may.
That's section 3 of M4. So proposals for new sites not outlined in policy M4 in brackets 1 and 2 will be supported in appropriate location, which
I see. It is. Yes, yes, it is. Yes. Okay, turning to Appendix A, the site allocations, Berkshire Manor. There wasn't a note in the previous schedule. There was a note to check whether Category 5 waste would be required. Has that been considered?
It was. I had further discussion with my colleague Alina on this matter, and as discussed previously, with the view that AD doesn't necessarily need a stack as part of that, it was considered that we didn't need to necessarily add that in. That was a note to ourselves for me to check, which I then subsequently did with my colleague.
Okay. Okay, and then right, this is reference main modification 85 in the latest schedule, which is again Berkshire Manor, and you put some text in there to refer to green belt compensation. Should that be expanded slightly just to explain what form that compensation would take, or what would be likely to be required?
That was in response of our discussion at the last hearing session with regarding the Corn Valley Regional Park. Corn Valley. So we could expand on that further. I think we don't want to be too rigid though at this point in time. I think flagging that up, that needs to be consideration, I'm comfortable with, but whether that needs to be a large amount of detail and how things progress, it's getting that fine balance of being too prescriptive, but sort of flagging up that needs to be considered. So I'm very happy to go away and have another look at that, see whether any further detail could be added, but I'd be conscious that I don't want to be overly prescriptive.
Okay. And then on transport, you've deleted the bullet point which says a new access onto Poyle Road is required. And I think that reflects the discussion at the hearing session that planning permission has been granted for a new access. But is it not still the case, even though planning permission has been granted, is that not still a requirement? That don't you still need to state that a new access would be required? So it's still an outstanding requirement.
The site is now operational. Poyle Quarry is now operational, so that new access is currently being used at the moment. So it wouldn't be that it's required in the fact that it's currently operational, the new access.
Oh, right, currently operational. Okay.
The main Poyle Quarry, that was part of the new access, was as part of that proposal for the new quarry, of which these are extensions of it.
Okay. Okay, and then in MM90, which is Monkey Island Wharf, and you've got some new text in there. Has that text been agreed with the Environment Agency?
Yes, that is a direct reflection of what comments we had back from the Environment Agency, which we received last week. So those now are the updates, some of which will be familiar from the previous edits, but this is now the agreed wording.
Okay. Right, now going on to the additional modifications, there was in the previous version of the schedule, there was AM3, which was describing its background text to policy DM3, and that was describing biodiversity net gain requirements, and that's been deleted altogether, that paragraph.
Yes, that as I sort of was mentioning before, this is sort of an evolving area, and speaking to colleagues who are now actually applying the new metric, they were saying that the additional text that we were proposing previously were almost the sort of foundation points of the metric, and could understand why we'd been sort of flagging them up as kind of key points. But speaking to colleagues that are now applying the metric, they felt that actually we shouldn't be sort of including those sort of details within the supporting text, because it was all built into the metric, and what the quote, including that text, was a risk there could be some forms of conflict potentially. So talking about the addition, saying we strongly encourage prior planting, for example. If you put a text in like that, it could be that someone goes away and puts a load of planting in, but it's the wrong type of planting. And then the previous text we'd had about the greater than 1.5 area, speaking through with a colleague, I say, who's actually started applying the metric, they said a lot of that is all in there, and it depends very much in terms of what type of habitat, where potentially that could be located. And within the metric, there's all these different detailed fields about where you can put those in, the types of habitats, where that would be. And again, even the prior plantings, you can put in specific dates about when that would be, and again, what types of habitat. So when to talk that through about applying that in practice, there was concern from their view that having a sort of general comments of that nature could potentially cause issues with trying to apply the metric itself. So we're more comfortable that we've got the references to the metric, that's what should be used, and that should be what's applied, rather than trying to incorporate some of the principles of how you use it in the supporting text, if that makes sense. Is how I understood them explaining it to me.
Okay. Okay, well, I mean that was a sort of brief run through. They were some of the main questions that that I had, and we will need to look at this in greater detail. But I think for today's session, I haven't got any further questions on the schedule itself at this stage. Okay, then. Have the authorities given any consideration as to whether further sustainability appraisal or habitats regulations assessment is required of these modifications?
Yes, we have, obviously, because there's been changes to the main policies. We would want to run those assessments again, just to check whether there's any changes for both sustainability appraisal and HRA.
Okay, Okay. Over what sort of time scale would that be?
We're hoping, because there's only been some significant changes to some of the wording of the policies, and in some cases, obviously, in most cases, these are all about strengthening the policies themselves. There hasn't been too many fundamental changes to the site's proposals. We, in discussion with the Berkshire authorities, we hope to be able to do that in the next 3 weeks. We would like to try and undertake the 6-week consultation before Christmas, which I believe would have a start date potentially then of the 8th of November, which is very quick. It's whether we can get that time, but that would be our intention, to try and aim for that time period.
Okay. Well, I mean, to give a broad indication, I mean, we can't, obviously the strategic flood risk assessment is a matter that needs to be resolved before we can sort of confirm the schedule of modifications. So that's the first bit of work that needs to be done before we can do that. And once that's been resolved, then we can consider the schedule of modifications. So just to give a few administrative requirements regarding the next steps. For each main modification, the schedule should show the text of the submitted plan amended with struck through text for deletions and bold underlined text for insertions. And this is the format required for the final schedule that will be appended to our report. Please avoid track change format and coloured text, as these do not always transfer well when the schedule is reproduced. The schedule should be in Word format, not PDF. The MMs should be set out in plan order, and each one given a reference number, as you have been doing. And please group all the necessary changes to any individual policy together into a single MM to reduce the overall number of MMs as far as possible. And that can include any consequential main modifications that arise as a result of a principal main modification. You may include a column, as you have done, on the right-hand side, the justification. I think that's optional, really, but it just briefly explains the reasons for each MM to help the representatives to understand the reasons for those changes. But ultimately, the reasons would be provided in our report. If any necessary changes to the policies map are necessary, they should be published alongside the schedule of main modifications for consultation, and also any updates to the sustainability appraisal and the habitats regulations assessment should be published for consultation at the same time. And you may wish to sort of draw attention to any revisions to the evidence base in the consultation, such as the strategic flood risk assessment. The consultation, it needs to make very clear that the consultation only relates to the main modifications. Any changes to the policies map and any sustainability appraisal, habitats regulations assessment, or the evidence base, and not to revisit the original representations to the plan itself. If the authorities wish to publish and consult on the additional modifications alongside the main modifications, then these should be set out in a separate table. That's up to the authorities if you wish to do that. And please make it clear that the additional modifications are not for our consideration. Okay. Other matters. The policies map suggests that there are inset maps. Are these to be produced in the adopted plan?
The inset maps are the maps that feature in Appendix A.
Right.
So you've got the development considerations, and then you've got the maps opposite, which should give an indication of the inset map reference.
Okay. Okay, well, we intend to adjourn the hearing at this stage because, well, we're not finished today yet. We've got a session this afternoon. So I suggest that we adjourn now. Are there any further matters before we adjourn for the morning?
Not from ourselves, sorry.
Okay. So, okay, if we can adjourn now then and come back at 2 o'clock, please. Okay, thank you.